Thank you for joining us this morning. Before we get started with the substance of this press conference, I want to introduce the people who are standing with me, as I like to do because they're the folks that did the work. To my right, and immediate right, is Paula Blizzard, Supervising Deputy Attorney General. To her right, Kathleen Foote, Senior Assistant Attorney General. To my left, Eleanor Bloom, Special Assistant to the Attorney General. They were very active in the matter that we're going to be discussing shortly, along with some of the team that was not able to join us this morning, and that would include Deputy Attorney Generals Nicole Gordon, Adam Miller, Brian Wang, Winston Chen, and Michael Battaglia, Supervising Deputy Attorney General Mike Jorgensen, and Senior Legal Assistant Laura Namba. I want to thank all of them for the work that they did on the matter that we're here to discuss. A little less than a year ago, last June, our state, as part of a coalition of states and the District of Columbia, asked the courts of this country to block a proposed mega merger between T-Mobile and Sprint over concerns that, unchecked, this merger would shrink the already consolidated wireless telecom industry, thwarting meaningful competition. It would also put lower cost plans that California relies upon at risk, and it could cost hardworking Californians their jobs. We took this case to court to fight for the Californians that we believe deserve that protection. Their interests need to be protected, and we went to court to ensure that no matter what the outcome, those concerns would be addressed. We're always going to fight to have consumer-oriented markets here in this country and certainly in our state, because that's what competition and a market-based economy demands: fairness and competition. That's why we built this coalition, which included more than a dozen states and the District of Columbia. That's why we took this case to court. A month ago, the district court involved in this case approved the merger, but its decision also made very clear to the companies around the world, and certainly here in America, who deal with telecommunications, that local markets matter. You may be global, but the local markets that you impact matter in assessing the competitive impact of a merger, and that no one should underestimate the role of state enforcers like attorneys general when it comes to ensuring that there is true competition. Today, we're announcing a settlement of this case with T-Mobile and Sprint, with conditions that will include protections for low-income subscribers, an extension of access to underserved communities, protections under the current T-Mobile and Sprint for its employees, and the creation of jobs in our state of California. The merged T-Mobile has committed to offering Californians 2 low-cost plans for service for at least the next 5 years. The merged company will also continue to offer plans that are in place today and that were in place as of February 2019, moving forward for at least the next 5 years at the same price. The merged company has also committed to providing free mobile broadband for low-income, unconnected households with school-age children for the next 5 years. That program includes 100 gigabytes of no-cost broadband internet service per year and a free mobile Wi-Fi hotspot device, up to 2 million of those devices per year for 5 years. That's $700 million worth of hardware available nationwide for 5 years. Families in the program will also have an opportunity to buy select Wi-Fi-enabled tablets at cost. This deal also protects California jobs. It ensures that all Sprint and T-Mobile retail employees in California in good standing will receive an offer of substantially similar employment with the new T-Mobile. And for the non-executive employees who, within the next year, join DISH, and DISH is a company which T-Mobile and Sprint have committed to stand up as a new competitor, T-Mobile, for these employees, will waive any applicable non-compete agreements for the next year. I want to make a note here that that particular provision about no non-compete agreements doesn't really apply to California, because in California, non-compete agreements are not enforceable. The company is also committed, or at least the new merged company has also committed, to ensuring that the number of T-Mobile employees in the state of California through in 3 years from now will be equal to or greater than the combined number of Sprint and T-Mobile employees today. Let me make sure that's understood. The new merged company has agreed that its employee base of the new merged company here in the state of California in 3 years will be equal to or greater than the combined number of Sprint and T-Mobile employees today. The new merged company has also committed to opening a new call center in Kingsburg, California, in the Central Valley of our state, which they anticipate will create approximately 1,000 new jobs in the state of California. And to facilitate further diversity in the workforce, the new merged company has agreed to work to reach 60% participation in its diversity inclusion program within the next 3 years. You see, you really can, despite the acrimony of litigation and lawsuits and court trials, you can really come to terms even with those with whom you go to battle in court. In this case, we didn't see eye to eye in the way things were done by Sprint and T-Mobile, but we saw eye to eye enough to reach a settlement that included protections for California's market and California's people. Finally, as a result of the settlement, the new T-Mobile Sprint company that's merging into just T-Mobile will also reimburse the state of California for the costs of our investigation and litigation within 30 days of the closing date of the merger. The other states that were part of our coalition, which are signing this settlement, will also be reimbursed for their costs. We expect that the total of those costs will be about $15 million. As we announced yesterday, the state of California has decided not to appeal the court's decision or to take any further court action in this case. I will say we're always ready here in the state of California and prepared to take on these kinds of fights when competition and fairness are on the line. It is important for California to know that in its state, the markets for its business, for any consumer's business, will be competitive and that pricing will be fair. And whether we have to go to court or not, or whether we're able to reach a settlement with companies that are engaging in California business, we will do everything we can to make sure fairness, competition, and good prices prevail.